case briefs, and so much more. LSData's got what you're looking for.
The 1967 Supreme Court case of Prima Paint Corp v. Flood and Conklin Mfg Company centered on a contract dispute between the two companies and established that claims of fraud in the inducement can be resolved through arbitration when a contract contains a broad arbitration clause. Federal courts must follow Congress's rules on contracts involving commerce, as demonstrated in this case. Under the contract signed on October 7, 1964, Flood and Conklin were obligated to provide advice and consultation to Prima Paint, among other services. In exchange, Prima Paint agreed to pay Flood and Conklin a percentage of its proceeds from specified customers, with total payments not exceeding $225,000. The agreement included a broad arbitration clause for any disputes that might arise between the parties. Prima Paint claimed that Flood and Conklin lied about their ability to fulfill the contract and intended to file for bankruptcy. Consequently, the court was presented with the question of whether the claim of fraud should be resolved by the arbitrator or by the court itself. Ultimately, the Supreme Court held that the fraud claim in the consulting contract between Flood and Conklin and Prima Paint must be decided by an arbitrator, not a federal court, in accordance with the U.S. Arbitration Act of 1925 governing dispute resolution via arbitration.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.